I'm here to help you manage copyright so it doesn't manage you. You don't want surprises from attorneys who aren't your attorney, you know, on the envelope. So we know as speakers how important it is to respect copyright. As we're crafting our presentations, we're doing research, we're gathering content from other places perhaps. We need to be aware of what the terms and conditions are that allow us to use that. Also, we may need to seek permission, which might involve a license. It might involve a license fee. So these are things then to keep in mind. You pull the pieces all together and you create a unique whole, a unique work, and you own the copyright to that. You own the right to reproduce, distribute, create derivative works, perform, or display publicly. Now that perform and display certainly come into play as speakers. You want to protect your copyright, your content, and your presentation. Once your presentation is down in a fixed format, either paper or perhaps recorded, that fixes the copyright. You don't have to do anything else, although I do recommend a couple of other things. When an organization pays you to speak, they may assume that they also own the rights to your presentation. So it's important to have those expectations and agreements written out, settled before you begin. Have that settled out in a mutually signed agreement. They need to be clear, they're mutually signed. How might they want to use your presentation? Do they want to record it and put it on the internet? Do they want to transcribe it? Do they want to use pieces in their training program? Do they want to use pieces in their marketing? And those are areas that might require some licensing. What do you want to do with the presentation? Do you want to have your presentation to that group videotaped or recorded for your use in your business? Might there be release forms required then with people who are present in the audience? If you're doing slides, PowerPoint slides, or handouts, think about those, how you want those to be protected, what you are being paid for licensing. If you have used some graphics that you had to license or content you had to license, you may not be able to share that with someone, with the audience in a paper format. You may have a license only to project it, to show it to a group that's not recording. So it's always important to have a written agreement. Social groups might be very unaware of how copyright applies in their situations. They may think that since they've paid you, they own the rights to your presentation. They may actually think that they would be helping you by in your marketing by putting your name and your message out there. And so they just aren't aware of sometimes some of those finer details. It'll be your responsibility to educate them nicely through the written agreement or contract. So spelling it out very plainly. Always have that written agreement so that there are no surprises down the road. And these and other tips are available through my report, Copyright Tips for Speakers. And you can find that at managecopyright.com. That's my website, managecopyright.com. And remember, we're not talking about W-R-I-T-E. We're talking about the right to make a copy, C-O-P-Y-R-I-G-H-T. And I'm Barb at managecopyright.com. Manage copyright, don't let it manage you. Thanks so much.